Next from Chicago, representatives from the Illinois Civil Justice League and the American Tort Reform Association, among others, expressed their desire to see tort reform as well as greater transparency of political donations from those in the legal field. This runs about 25 minutes.
Good morning. I'm John Pastuvic, President of the Illinois Civil Justice League. Up with me here today in order of appearance are Al Adamite, Executive Vice President of the Illinois Civil Justice League, Tiger Joyce, President of the American Tort Reform Association, and Travis Aiken, Executive Director of Illinois Lawsuit Abuse Watch. Today, we are going to reveal the findings of a new study titled Justice for Sale 3, completed by the Illinois Civil Justice League and released in conjunction with Illinois Lawsuit Abuse Watch and the American Tort Reform Association. The study reveals the campaign contributions by trial attorneys to Illinois politicians and judges has topped $35 million over the last 15 years. In addition to the $6 million contributed through the Illinois Trial Lawyers Association Legislative Political Action Committee, the top 25 plaintiff firms and their lawyers and family members collectively invested $29 million in the campaign of Illinois office seekers from January 2001 through March 2016. These campaign contributions have gone to legislators, constitutional officers, judges, state's attorneys, county board chairmen, circuit clerks, county party chairmen, mayors, union leaders, and politically allied special interests. Our studies document a truly staggering flow of plaintiffs' bar cash. The more than $35 million in contribution equates to roughly $264 a day, every day of every week for the past 15 years. The study also shows that 98% of these trial lawyer donations were directed to the most powerful incumbent politicians in Springfield and other Democrats. While ITLA's PAC and plaintiff firms donated millions, policymakers they supported made Illinois tort laws even more to the trial attorneys' liking. During the study period, Madison County set an infamous national record for the most new class action filings in a year, and a statewide medical liability crisis threatened critical care for Illinois patients. Meanwhile, lawyers and judges in Madison County built the nation's largest and most notorious asbestos docket, attracting more than 13,000 individual asbestos cases in 15 years. In fact, sources now estimate that 1/4 of all asbestos cases filed nationwide are now filed in Madison County. With an estimated outcome of $2 million per case, the Madison County asbestos rocket docket could be worth more than $1.74 billion, that's with a B, annually, and could produce nearly $600 million annually in contingency fees for plaintiff attorneys. Additionally, just last month, a couple of weeks ago, the Illinois Supreme Court, in a 4-3 party line decision led by Justice Thomas Kilbride, derailed a bipartisan movement comprised of more than 500,000 Illinoisans and various good government groups who wanted to give voters a chance in November to decide whether an independent committee should draw nonpartisan maps for legislative and judicial districts instead of maintaining the one-party gerrymandering status quo. It's no coincidence that the trial lawyer-funded Democrat Party donated $1.5 million to Kilbride's 2010 retention campaign. Interesting, if not surprising, is the fact that the biggest trial lawyer donations supported campaigns in Cook, Madison, and St. Clair counties, each widely known as once and future judicial hellholes. And you'll hear a little bit more about the judicial hellholes in a moment. And when one considers that these counties also host the state's highest concentration of lawsuits, it's fair to ask, is justice for sale in Illinois? Now to discuss some of the details in this study, I'd like to introduce Al Adamite, Executive Vice President of the Illinois Civil Justice League. Al?
Good morning, and thank you, John. A large majority of the donations given to legislative leaders, individual senators, and representatives were given through the ITLA legislative PAC. The PAC then distributed 2,624 individual donations to the campaigns of 320 different legislative and statewide constitutional office candidates. As displayed here in the graphic to my left, 98.6% of these donations went to Democratic candidates. Some comparisons, 51.5% of the PAC contributions went to House leaders and candidates, 32.7% went to Senate leaders and candidates, leaving the balance of 15.8% to candidates for statewide executive offices. The largest benefactors were the Senate Democrat leaders, Emil Jones and John Cullerton, who collected $713,600 in PAC donations in their 4 leadership funds. House Speaker Mike Madigan was the second largest benefactor, collecting $658,500 in PAC donations in his 3 leadership funds. Additionally, former Illinois Governors Rob Blagojevich and Pat Quinn, current Illinois Attorney General Lisa Madigan, and former Illinois Comptroller Dan Hines are all favorites of ITLA's PAC, receiving $237,000, $156,000, $105,000, and $63,000 respectively. The coverage of legislative giving is astounding. Under the previous legislative map, for the years 2001 through 2010, PAC contributions were given to candidates in 56 of 59 Senate districts and 103 of 118 House districts. In the 3 cycles under our current legislative map, PAC contributions were given to candidates in 43 of 59 Senate districts and 85 of 118 House districts. Of course, the districts under the new legislative map, as has been recently reported, are much less competitive as they've been much more narrowly drawn, and there doesn't seem to be any hope for remedy of that after the Supreme Court's decision last month. I want to quickly expound on the study's composition and methodology, including the research that went into documenting the $29 million in donations given outside of ITLA's PAC. So again, the study concentrates on the $6 million within the PAC and the $29 million outside of the PAC, and that's what gets us our $264 every hour for the past 15 years. Based upon the level of law firm and attorney giving to the PAC, we were able to total the contributions given by each firm and its attorneys over the past 15 years. Not coincidentally, 2 law firms tied for the most given to the PAC, each at $265,600. So we don't know exactly how their PAC giving works, but it does seem to be regimented in a way that is set and structured, and it's apparent that certain firms are encouraged to give a set amount. Over the study time period, we looked at the top 25 firms that have given to the PAC, and 8 of those 25 firms have given over $200,000 and another 7 over $100,000. However, the non-PAC giving was substantial by the total of these 25 firms. Of the 25, the largest amount given was by the Madison County-based asbestos firm led by John Simmons. It's originally the Simmons firm, then the Simmons Cooper firm, now Hanley, Conroy, and Simmons. Their leaders have given almost just under $5 million to Illinois politicians over the study period. The Chicago-based Clifford Law Firm gave more than $4.6 million, and 7 firms in total topped $1 million, and 15 of the 25 the firms topped at least $500,000. We should remind our readers that we only researched the top 25 firms for the non-PAC donations, which again totaled more than $29 million. It's possible that with an unlimited amount of time and effort, this number would grow larger if we surveyed the State Board of Elections site for all the other 300 plus additional donors to ITLA's PAC, donors that gave somewhere between $100 and $70,000, but unfortunately did not rank in the top 25. The non-PAC donations to the legislative leaders and reps and senators are exponentially greater than the PAC donations. For example, while Speaker Madigan, as I mentioned, received about $650,000 in PAC donations, his 3 leadership, the speaker-controlled campaign funds received $6.8 million in non-PAC funds, or non-PAC giving that was outside of ITLA's legislative PAC. While PAC donations to the funds controlled by Senate Presidents John Cullerton and Emil Jones topped $713,000 from ITLA's PAC, the non-PAC donations to the same funds were nearly $1.9 million. Many of the largest individual legislator benefactors of the trial lawyer donations are districts that are centered around, and you guess it, Cook, Madison, and St. Clair counties. I strongly encourage you to take a look at the maps on pages 12 and 13 in our report that visually depicts the House and Senate districts that have the largest geographic concentration of campaign donations. It visually depicts the concentrations around Cook, Madison, and St. Clair counties. Now, a quick note about contributions from trial lawyers to judges, especially the donations that came outside of their legislative PAC. There were $3,171,923 given directly to Supreme Court contests, and 95.6% of those donations were invested in the 5th or 1st judicial districts, the districts that include Cook, Madison, and St. Clair counties, which are often cited as judicial hellhole counties by our partners at the American Tort Reform Association. 99.9999% went to Democratic Supreme Court contests or to oppose Republican Supreme Court candidates. That's right, so 0.0001% were given to Republican candidates. I can sum that up. That was a $500 contribution given by the Clifford Law Offices to Citizens for Rita Garman on December 3rd, 2001. So it's very distinct that most of the judicial contributions are going to Democratic candidates. Millions of dollars of trial lawyer donations have also been flowing to local Democrat Party committees, municipal races, and countywide contests. Trial lawyer donations totaling $1.4 million were given to local party committees in 17 of Illinois' 102 counties. 99.5% of those donations went to Democratic Party committees. Contributions to countywide contests totaled $1.8 million, and those with donations to Democratic candidates accounting for 97% of the donations. Donations to county officials and candidates in Cook, Madison, and St. Clair counties accounted for 95% of all donations. So the concentrations on these 3 counties, as well as a couple other counties in the Southern Illinois-based 5th Judicial District, are of no surprise in our research. As John mentioned, the latest report on county-by-county per capita lawsuit filing data that was released last year by the Illinois Civil Justice League in our litigation imbalance series showed that the average number of civil lawsuits per 1,000 residents for the 99 counties that aren't judicial hellholes in Illinois averaged about 1.25 lawsuits per 1,000 people. That average is double that in St. Clair, it's triple that in Cook, and it's 6.5 times that in Madison County. So again, considering the dramatic disparity in lawsuit filings for those counties, it's unsurprising that trial lawyers would flood campaign donations to just those 3 counties. It's my pleasure to introduce Tiger Joyce from the American Tort Reform Association. Thank you for being here this morning. Tiger.
Thank you very much, Al, and to John Pastuvic and to the Illinois Civil Justice League for allowing me to join you today. Particularly want to commend the ICJL for this outstanding report, which I think is important to look at and consider, and with regard to the point that I really wish to make, which is the failure of the leadership, the political leadership in Illinois, to enact meaningful legal reform, to undertake reasonable steps to fix clear abuses in the system. So let me highlight that a little bit. You've heard a little bit of discussion of ATRA's Judicial Hellholes Report. Our report is a document and report generated each year towards the end of the year by our affiliated foundation. And regrettably, as I've come to the state a few times in the last year or two, highlighted the fact that unlike some places where meaningful reforms have helped to move jurisdictions off of our report, Illinois has proved to be continually and persistently reluctant or outright refused to take reasonable steps to achieve reform. I do want to say that civil justice reform is an important component of addressing what are widely regarded as historic problems in your state with the budget and the overall economy of your state. You don't have to believe me. All you need to do is look around others in the region. When you look to Wisconsin, Ohio, Michigan, Indiana, even a little further into West Virginia and Pennsylvania, which are launching efforts, and West Virginia successfully got itself off of the judicial hellholes report by enacting meaningful reform in the last couple of years. And even we're optimistic about your neighbors in Missouri, where we're hopeful that 2017 will be a terrific year. But I really want to use the abuses and the problems that are really the most significant perennial problem of Madison County, and in particular the asbestos litigation, as an example of why addressing these reforms and dealing with these issues is so particularly important. In a somewhat disparaging way, we simply say Madison County has allowed itself to become a dumping ground for asbestos cases. I think that most people would like to think of their community in a little more elevated terms than simply being a place where everybody goes to file lawsuits, particularly asbestos cases. And this has been well documented, as I said, in our judicial hellhole report. John mentioned estimates of a quarter, even as much potentially as of a third of all the litigation in the United States involving asbestos claims. This is important litigation, but is being brought in Madison County. What really illustrates the abuse, though, is that over 90% of the plaintiffs in these cases have one thing in common, and that is they have nothing in common with Madison County. Courts and the judicial system are really intended to be set up for the people in those communities, not for people outside. And that, in and of itself, is a fundamental problem. And I think, as the Illinois Civil Justice League documented last year, on a per capita basis, compared to Cook County, where we are obviously right now, asbestos case filings are 168 times higher than they are here in Cook County. Madison County filings are 168 times higher than they are in Cook County. Now, if you're a defendant in one of these cases, oftentimes you hear something called a rocket docket. I'm a lawyer, and you like to think things move along quickly. But if you're one of the lawyers who finds that there are potentially 209 cases that are going to start trial in a given week, you're going to look at that situation and say, this is hopeless. We have no opportunity. Fundamental fairness and due process are really out the door. That rocket docket is abusive. It should be fixed. And also, in keeping, just to illustrate, of those 209 cases, only 19 were from Illinois. And in a later week, there were 316 cases were planned. Only 7 were actually from Madison County. So it is clear that it has become a dumping ground. This is a situation where judges are not doing their jobs. They're not doing their jobs by ferreting out the cases that don't belong there, addressing that issue. They have a lot of discretion. It should be addressed. Your governor has called for fixing this problem through the legislature. Unfortunately and regrettably, that has not happened as well. We think that the ICJL report sheds important light on why this is not happening, and sets, and I think for elected officials, for those who care about public policy, and in particular the legal system, there should be a lot of questions asked of those public officials. Why aren't we fixing, why isn't the state fixing its venue rules? The governor has called for addressing joint and several liability, a very reasonable reform that has been enacted in virtually every other jurisdiction in this country. And the failure to address that, I think, speaks volumes. It puts you at a competitive disadvantage, and I think ultimately is an indicator that the problems more broadly in the state are going to continue unless and until they're addressed. I would finally just conclude that the answer to this issue is to challenge those accepting these campaign contributions, to do what's best for the state, to recognize that reform is in the public interest, and in particular the reasonable and modest proposals that have been sought, and then to address key issues that John mentioned, like medical liability and others that had been addressed previously and need to be reinstated and reformed. So we look forward to highlighting those successes. We hope that that this outstanding report of the Civil Justice League will be a catalyst towards those reforms, and look forward to commending Illinois for that important success. And again, our congratulations to the ICJL. I'm now pleased to turn the podium over to Travis Aiken of Illinois Lawsuit Abuse Watch.
Thank you, Tiger. It's always good to see you here in Illinois. As Tiger well knows, Illinois is indeed one of the worst states in the country for legal fairness. Madison County continues to rank as one of the worst judicial hellholes, and neighboring St. Clair County, along with Cook County, where we are today. Also make frequent appearances on the Judicial Hellholes Report from the American Tort Reform Foundation. Illinois is also ranked the third worst state in the nation for legal fairness, according to a report from Harris Poll. The culture of lawsuit abuse in Illinois is driving jobs and opportunities to other states. We just recently saw in the news some information about how Illinois has lost 354,000 adult residents from 2005 to 2015. These are workers. These are people who are in the workforce, and we've lost a lot of them in the last 10, 15 years. We're also losing workers at an alarming rate because there are no jobs. The reality is that creating new and meaningful jobs in Illinois is the solution for every major issue facing the state today. And the best way to start to turn around Illinois is for voters to elect legislators who will embrace the Governor Rauner's proposed lawsuit reforms, such as venue reform, to stop personal injury lawyers from venue shopping to favorable Illinois court jurisdictions. We've heard a lot about those jurisdictions today: Madison, Cook County, and St. Clair counties. What Illinois needs is jobs, not more lawsuits. And today we learned we now have 35 million reasons why Illinois counties continue to attract lawsuits and personal injury lawyers from all over the country, and why we are shedding jobs to neighboring states. This study proves that personal injury lawyers are gaming the system to their advantage by fueling millions of dollars in campaign contributions to Illinois judges, who continue to allow these junk lawsuits that have nothing to do with Illinois to move forward here, prompting the very real question: is justice for sale in Illinois? Personal injury lawyers fuel the campaigns of judges, who then make favorable rulings for their campaign donors, which generates even more money for these personal injury lawyers to invest in even more judicial campaigns. It's a vicious cycle that has to be broken. We need to stop the cycle at its source by ensuring that Illinois is no longer a favorable destination for lawsuit tourists. When personal injury lawyers continue to game the system to their advantage, it is no wonder our state has become a favorite destination for personal injury lawyers looking to hit the lawsuit lottery. And when one avenue of lawsuits dry up, these personal injury lawyers go out and find new ways to sue, even looking to other states to find these new lawsuit opportunities. For instance, here in Cook County, the wave of ADA lawsuits has plagued the state of California, is now plaguing the state of Illinois. And we're seeing more and more ADA lawsuits, Americans with Disability Act lawsuits, filed right here in Cook County. And then, of course, we have the notorious judicial hellholes, Madison and St. Clair counties. The problems in Madison County are well known, are all across the nation. Madison and St. Clair counties continue to be ranked as perennial judicial hellholes, due in large part to the close connections between the judges in those two counties and the personal injury lawyers who fund their campaigns. One of the most basic ways to stop lawsuit abuse in Illinois is to elect judges who will stand up to the personal injury lawyers and say no to frivolous lawsuits. With their tremendous power over what takes place in their courtrooms, judges can help Illinois shed its reputation as a plaintiff's paradise. Who is serving on the bench matters. Electing good judges who apply doctrines of common sense, fairness, will help stop lawsuit abuse in Illinois and help our state attract employers who currently don't want to risk moving to a state where they'll immediately have a lawsuit target on their backs. Voters will have a chance to deliver their verdict on judges who take the majority of their campaign funding from the personal injury lawyers who've turned the land of Lincoln into a job-killing land of lawsuits. Illinois judges who will stand up to the personal injury lawyers and return common sense and fairness to our courts. We need those kinds of judges serving on the bench today. This report highlights the cozy relationship between judges and personal injury lawyers who fuel their campaigns. Law firms have every right to be a part of the political process, but the public needs to know what they are doing and who is benefiting from their campaign contributions. There's an old expression in journalism, follow the money. When it comes to judicial elections, voters need to follow the money. It will turn and then make an informed decision when the appropriate time. So with that, I will turn it over to John. Thank you.
Thanks, Travis. Are there any questions? If not, I'll give you a chance to get your cutaway shot. All right.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.